Welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, we're going to talk about a big Ninth Circuit case that just came out that deals with the CSPA. That's the Child Status Protection Act. And it affects essentially anybody who has waited years and years for a visa number to become current and has aged out. Okay, meaning that if you're over 21 and the visa number became current, but when it was first filed, when the petition was first filed, you were under 21, then this might apply to you. So let me give you a little bit of a background so that you have an idea of where this case came from, why they ruled like they did, and how it can help you or somebody you know to try to come into the United States under the CSPA as a derivative, dependent, or as somebody who's over 21 with a direct petition, but nevertheless aged out. Now, let's talk about first family-based petitions. Okay, and what we're talking about here is the first preference, 2A, 2B, third preference, and fourth preference. Now, what are all of those? And again, I'm explaining these so that you will have an idea of the importance of this case and how it may impact upon you when you thought that all was lost and you'd have to wait another 10, 15, 20 years or never to be able to come into the United States. Now, First of all, whenever you have a family-based petition, and we're not talking about immediate relatives, ones that they have no visa numbers and they can, or there's no priority dates, there's no waiting, they're always available. We're talking about the ones that that there's a priority date set, and that only when it is current can they come in. Now we have a petitioner and we have a beneficiary. Okay, the petitioner is the person who is asking for the beneficiary or the other person to come into the United States or obtain eventually legal status. The petitioner is one of two things. It's either a U.S. citizen or a lawful permanent resident. That's what it comes down to. If you're not a lawful permanent resident or U.S. citizen, forget it. Okay, you can't do a family-based petition under these categories. So if you're a U.S. citizen, you fall under the first preference, the third preference, or the fourth preference. Okay, now what does that mean? Well, the first preference are sons and daughters of U.S. citizens. Okay, those are not children. Those are persons who are over 21 who are sons and daughters of U.S. citizens. Now, what I'm about to tell you does not apply if the petition is initiated or started when the beneficiary is over 21, because then you can't argue that you waited all these years for it to become current and then you turned 21. No, you have to be under 21, so the first preference won't apply here. The second preference, now 2A is referred to as 2A and 2B. The second preference deals just with lawful permanent resident petitioners. Okay? Now, 2A will be spouses and children of a lawful permanent resident. Now, the children is specifically defined as a person under 21 who's single. Okay? If you're over 21 or married, you're no longer a child for immigration purposes. So, if you're 14 and get married, well, there you go, you're not a child anymore. And then 2B would be a single son or daughter over 21 of a lawful permanent resident. Okay? So again, if you just start out with preference 2B and you're over 21, forget it. That's not going to work. But the way the immigration works is once the preference changes, meaning once you fall into the next category, it automatically changes. So, for example, lawful permanent resident petitions son, let's say that's 18 years old, okay, and that's preference 2A. Well, let's say 4 years pass before it becomes current, which is certainly not unheard of. let's say that the child is now 22 years old. Well, it will then go to preference 2B automatically. Okay, and that's the type of case that I'm talking about, where it starts off where you're under 21 at a particular preference, and then it moves to another preference automatically because you're over 21. Now, third preference, what's that? Well, that is married sons or daughters of U.S. citizens. Okay, and I'll tell you in a minute where this is going to become applicable, but if you're the direct beneficiary, and that's the direct person you're petitioning, the son, the daughter, the mother, the father, the brother, whatever, then that won't apply. Now, the fourth preference, that will be sibling petition of a U.S. citizen. So that is someone who's a U.S. citizen petitions his or her brother or sister. And the fourth preference, let me just tell you as an interesting fact, if you're from the Philippines, the fourth preference petition is the longest wait on the planet of any country. It currently takes about 22 years. And believe it or not, there's people that wait. Now, for direct beneficiaries, really, of all those preferences I just told you, we're talking about primarily just preference F2A. Okay, everything else, you're over 21 at the time. So basically, the way that this new Ninth Circuit case works is it also looks not just at the primary beneficiary in what I just told you, but even more importantly and more often, the derivative beneficiaries. Now, what is that? And again, I have to explain this so you understand the importance of this case and how it might affect you. Well, a derivative beneficiary is someone who's not directly petitioned, but yet when the visa number becomes current, they are able to then come into the United States. They hitch on the coattails of the primary beneficiary, and then they come in. So let me give you an example. Let's say that we have a sister petition her brother. Okay, and let's say, again, I'll use the cases from the Philippines or Mexico or China, somewhere that has long visa waiting lists, which all of, even the shortest fourth preference petitions about 7 to 10 years. But at any rate, the way it works is the petition goes forward, and let's say that at the time that this lady, this U.S. citizen, petitioned her brother, let's say her brother was married and had 2 kids. Now, minus the CSPA and minus this Ninth Circuit case and other cases that have come out, if when the visa number becomes current, the children are under 21, then the spouse and the children can follow to join, and they can come into the U.S. essentially the same time as the brother, the primary beneficiary. And so, essentially, you have one sister petitioning one brother, but in the end, you're going to get the brother, the spouse, and the 2 children that are able to come in to the United States. And that's if the children are under 21. Now, if they're under 21, there's no issues. We don't even have to continue. You can say goodbye and go have some pizza. But it's when the priority date, it takes years and years to become current, and let's say that when it becomes current, let's say now the 2 children are 24 and 26. Okay, well, not looking at any other law, those 2 children can't come in. Only the spouse and the primary beneficiary. So in this case, what we're talking about is the children. And it's the same thing for the other preferences. Let's say you have U.S. citizen petitions son or daughter. First preference. Well, again, if when the visa number becomes current, those that son or daughter has children, and they're under 21, they can come too. But if they've aged out, if the children have aged out, then again, without looking any further, they're going to have to wait many more years for a different kind of petition. And we can go on. Each preference has this type of situation where there's a possible age out. I mean, again, look at third preference. You have a U.S. citizen petitioning a married son or daughter. Well, that's going to take longer to become current, and very possible they might have children, and very possible the children might age out. So essentially, while it is possible to use what I'm going to tell you for the direct beneficiary under preference 2A, it is also, and more likely, possible on any of the other preferences once the children age out. So again, look at the important fact here. Look if you're under 21 when some petition for your family was done. You don't have to know the specifics as first or third or whatever. Just when you're under 21, was some petition done? And now, are you over 21 when the visa number becomes current? If you're in that category, then I'm not saying, guarantee you're under this CSPA, but they're certainly worth a look at it because you saw how long it took the first time. Why not see if you can go forward and do what you need to do in order to obtain residency? So now that I've laid the groundwork, let me tell you what has occurred. Well, there's a provision of the CSPA that in a case just like I told you, where the child ages out, it said very specifically. It said if in this case the child aged out from a preference petition, then essentially two things happen. One, another petition is immediately created. I mean, it's sort of fictional, but it's immediately created from the original beneficiary to the child, and I'll give some examples so this will become clear. So it's immediately created, and more importantly, the original priority date is used in this fictitious petition. And so you look and see if in that particular case, if the visa number is current, and if it is, then boom, the person can come right in. And it's a very powerful provision. And the thing is it was quite clear. So I had lots of cases where immigration would say, no, that's not what it says, and then I'd have to fight it, and some would agree, some would disagree, some we had to go up on appeal to court, and so all over there were immigration, and even the Board of Immigration Appeals came out with a decision that essentially said, nope, that's not what it says. You cannot recapture the old priority date. There is no fictitious petition that's created, even though when you look at the words of the CSPA under this particular provision, it was clear that's what it said. It's not, as lawyers trying to, slide on the gray line here and make something that doesn't exist. It was clearly in there, but for whatever reason, immigration, the BIA, nobody wanted to abide by it because there would be a floodgate of people coming in because there's a lot more people that would qualify. But it went all the way up to the Ninth Circuit and just came out. The Ninth Circuit ruled, yes, that is the proper provision, that is the proper interpretation, and that immigration cannot deny petitions based upon this basis, and that the CSPA does say what it clearly says, and it does mean what it clearly means. Now, what is that? I think some of the best way for me to explain this to you is to give you a real example. Give you an example and show you what happens. So let's say, again, let's use the third preference. It doesn't really matter. And let's say a father petitions his married son, okay, under third preference. And let's say at the time the petition goes that the child is 10 years old, okay. Now, given that, let's say that the visa number doesn't become current until the child is 22 years old. So let's say it takes 12 years, give or take, for that visa number to become current. And let's say the child aged out. Well, first, and this is not the subject of this particular video, I have other videos. First, under the CSPA, you have to calculate the age of the child under immigration, the immigration age under the CSPA, and see if you can get to a point where even though this son, let's say now is 24 years old, let's say under the CSPA, once you calculate the age, you might be able to calculate it as being actually under 21 years old. And that's a subject for another day. But let's say you went through those calculations and it didn't happen. The child is not 21 years old under the CSPA, under immigration law. So now what you do, let me again recap the facts here. You have a father petitioned a married son, let's say 12 years ago, and the visa number just became current, and that child had that son had another child who basically was 10 years old at the time, and now let's just say he's 22. Okay, he's just over 21. Now what happens, and this is under the current law, at least in the Ninth Circuit and some other circuits as well. Now what happens is the son, now a fictitious petition basically is automatically created from that son to his son, the child who aged out. Let's call the child A, and let's call the son Tom. Okay, so now Tom is now a lawful permanent resident because his father petitioned him many years ago, 12 years ago. So now the fictitious petition is now the son, which is Tom, has now issued basically a petition to his son, and it would be a lawful permanent resident petitioning a child on or a son over 21. So that's preference F2B. So that you look at that now. That petition now, boom, magic, comes out, and that is the petition that now exists. Now, the issue then is, what is the priority date that you use on that newly fictionally created petition? Well, there you now go back to when the father, 12 years ago, petitioned the son. You use that priority date. So now you stick the priority date of over 12 years ago on this newly created fictitious petition from Tom, the son, to his son, and now you have a petition that was just created, but it looks like it's been waiting for 12 years. And now you go to the visa chart and you see when they are currently processing F2B petitions for this category, for this country, and in many instances it will already be current, meaning that you can turn around and now file the following to join in consulate processing, and the son who aged out can now come into the U.S. without any problems at all by filing the proper petition. Okay, I know that sort of wove through some facts and might be a little confusing, but it's exciting that this case came out, that it ruled like it did, because now even if years ago they denied you the petition, let's say you're watching this video from Mexico and 6 years ago you were in a similar situation. Well, I tell you what, you can still go forward. We can still file the following to join petition under the CSPA, and even if the visa number wasn't current back then, once you recapture the priority date of the original petition, it may very well be current now. So this is a very, very good development in immigration law and the CSPA. All I would suggest is that, without fully understanding what it is that is in the requirements and so forth, that all you have to do is ask yourself two questions. One, were you under 21 when somebody in your family had a petition filed for them? Two, are you over 21 now? Okay, that's all you got to ask. Obviously, if you're sitting there listening to this and you have a green card or you're a U.S. citizen, it doesn't apply to you. So if you're under 21 when it was first filed, and now you're over 21, can you come into the U.S. or adjust status based upon this provision of the CSPA? Okay, so give me a call, email me, get in contact with me. I'll be happy to give you a consultation, and from there, we'll see what we can do to see if you fall under this new provision. Actually, it's this old provision of the CSPA, but this newly enacted ruling from the Ninth Circuit, verifying what we've been trying to fight all these years.